Thanks very much. Welcome back, everybody, and thank you for keeping our short break as short as possible. We're going to pick up exactly where we left off, which was residents' questions to the application.
Just a quick technical question, if I may. Most of what I wish to say is going to be observations on the application itself rather than questions to the applicant or his representative. Are you happy for me to do that later, or do you want it?
If they are relatively short observations, yes. Otherwise, if you can frame them in the form of a question that could get a response, that would be appreciated.
Okay.
And my understanding is that I'm going to get the opportunity to read a brief statement to you. Is that correct?
Yes, it's absolutely right. Each party will have the opportunity to address the subcommittee. We're questioning the other party at the moment.
Thank you.
We will move on to each
see.
of you separately. You'll have your opportunity to address the subcommittee, and then everybody will be able to ask you questions. So everybody gets their fair crack of the whip.
Are there any further questions for the application from members of the public? No? Okay. Before we move on, I would just like to say, is there anything else that the application maker would like to say that they haven't already mentioned?
Not at this stage, sir, no.
No, lovely. No further questions. Members, any further questions for the applicant? Councillor Strudwick?
Sorry, your new manager, could you just explain how much experience he's got?
My apologies. Yeah, his name's Fabio Mazzoni. He has a number of years' experience. He's worked in the city of Portsmouth for the last sort of 5 or 6 years, I believe. He's a DPS licence holder. He has been a DPS in the city with no issues on his last DPS, and yeah, he's a very experienced operator.
Has he got experience both of operating dry and wet trade?
Absolutely.
Fantastic.
Very good.
Thank you. Anything from licensing? No? Lovely. In which case, thank you very much. We will move on now to the case that the residents would like to bring before us. Will all three of you be speaking in this section? You are entitled to. I just want to check.
It's probably going to just be two of us.
Okay.
I'd like to read a brief statement and outline of our concerns that my partner Laura and I have prepared, and then Mike is going to follow up with some more technical points.
No problem at all. Please do proceed.
Chair, I think it's probably there's some video footage to be
Oh,
viewed
yes,
as well.
that's a
isn't
good point.
I don't know whether...
Members, do you want to see the video footage before or after the residents have made their statements?
I don't know if the residents have a view as to whether they would like it to be viewed first or after you've made your points. It might make sense to view it first, and
Yeah.
then you can talk about it
Yeah,
after.
thank you.
Lovely. Rocky, is that something we can pop up? No problem at all.
Do we need to pull blind or anything?
No, it's going to have to be off my laptop.
Okay.
John has to see this. Okay, so.
Sorry.
So can we just explain which clip we're watching first, so that...
So this is the first clip taken from across the road, and it shows the people outside of SBK.
Sorry, what time of the night?
Can we watch that one?
Yeah, 1 second.
Once
Do you wanna
more.
watch it again?
Yes, please. And do we know what time of night this was recorded? Thank you. So there's door supervisors there. I'd say this was a queue for entry.
Are
And
you,
who was it
you
that
satisfied you understand which clip is being viewed by... No, okay. I think what we'll do is, once you've seen it a couple of times and you're
Pass it
satisfied,
over.
pass it over. So
Yep, absolutely.
And then
And the second one?
and,
second one.
and also to the applicant's solicitor as well, so that they're aware of precisely what you're seeing.
Yep.
And this is from the same side of SBK.
Different night? Or same night?
Different night.
Different night.
And once more, please.
Jump in.
Yes, please. I can't tell where that music's coming from.
Yes.
But it doesn't appear to change when the door didn't open, then there was no change, so...
So, just for the record, the first one was taken on the 27th of May at 22:48 hours.
Sorry, 27th of May.
At 22:48. And the second one was on the 1st of July at 23:23.
Just check what days of the week those were. Is everyone happy with the video clips we've been shown? Well, happy that you know what we've seen. Yes. Okay.
There is another video that was sent in by Mrs. Fricker that hasn't been shown. I don't know whether Mr. Stone can find it. It's more audio than anything. It's a lot of screaming going on. It was taken from within her bedroom shortly after midnight. And while the applicant may seek to say that we can't prove that it was anything to do with SBK, I also have here an email exchange which Mr. Stone has seen and I gather has been shown to Mr. Walsgrove, showing that this was sent to the DPS shortly after it was recorded at about 7 minutes past midnight, and that he responded about 19 minutes later, I believe, to say that the woman concerned has been banned from the premises for 3 months. So there's a clear link there.
I'm afraid I was only given the email about 3 minutes before coming in, so it's not something which can be admitted.
Well, I appreciate that point,
Mr.
but-
Stone, well,
Yeah.
can you just let me finish? Mr. Stone advised me there was a third clip which he had determined couldn't be put before the committee because literally it's a mobile phone recording behind in someone's room where the curtains or blinds are drawn, so you can't actually see what's happening. It's a scream of a woman. The manager, the current DPS, had sent to me a video clip which was exactly as described by Mr. Stone, of someone in their bedroom or room with the blinds or curtains closed and a woman screaming. I spoke to the manager when he forwarded me that clip and he said, oh, we were actually closed, this has nothing to do with us. But I'm just recounting what my instructions. I don't need any accompaniment from those at the back of the room. So I had assumed it was that video. There seems to be some confusion whether the clip that Mr. Stone has is the same clip that I was sent by the manager. There's also considerable confusion about whether the email that has been produced is in fact from our manager. I query it because there's a question over the date it was sent, and there's a timing where it says CEST, which apparently is European time or something, which, if it had been sent from the manager, would not have had that time on the email. So there's discrepancy over whether it's valid anyway. But in any event, it was produced too late. It can't be admitted, so I'm asking you to exclude it.
Chair, by the sounds, the video clip, and I'm just running through this, please correct me, anybody, if I'm wrong with my understanding of the chronology of events. The video clip was submitted by residents in support of a relevant representation in advance of the hearing, with an indication that they would wish to rely on it at the hearing. The licensing officer has viewed it and considered it to have potentially little impact in terms of the decision making today. However, I would suggest, my advice would be that the decision as to whether or not it's admissible and or whether you take it into consideration, or the weight that you wish to attach it, is a decision for yourselves. I appreciate what Mr. Walsgrove is saying about not having had any notice of the evidence being produced or relied upon, and perhaps not even having been served with the particular evidence. However, if that does need to be addressed, it can be dealt with by way of an adjournment, either to a different date, so that that can be considered properly and instructions taken and with a view to considering it properly, or a short adjournment today for him to view it, consider it with his clients and return. That's my advice, but I'll hear any other representations if anybody wants to make them, Chair.
Thank you, Ben. I'm just having a quick look through my pack of papers because I do remember there being one of the written representations that did make reference to including a video with that. I'm just trying to find which one it was. If anyone finds it before I do, please shout.
To be honest, I don't think that point's really determinative, because
No, but
I don't
if
think
it
it's
was
disputed by anybody that it was
No.
submitted by residents in support of their.
Yeah,
in
in
support
which
of their
case
relevant
I will
representation.
consult with the other members of the panel, but I think when it comes to determining
If you
how
feel you
relevant,
need to take to adjourn
I
to
think
take legal advice, then
I'd like to see it so that I know whether or not I think it's relevant. I can't make a determination on whether or not I think it's relevant to the case without having seen it. And I'd be more than happy to offer up a 15-minute adjournment if you want to view the video as well.
Mr.
I
Wall-
don't have any objection to the video clip being shown, because I accept entirely the legal advice you've had that it was submitted before the hearing. So although I've not seen it, I don't have any objection to you seeing it.
And obviously we
The
would give you the
objection I
opportunity as
had
well.
was to the email, which is a document which has to be excluded. You can't take that into account. So you can see the clip, and we can all comment on it, and you can draw your own conclusions.
Okay. Mr. Stone, how long will it take for us to bring that clip up, please?
I'm trying to find it now.
Okay.
Because it
In
wasn't
which
actually,
case-
it was sent in by a third party. This is the problem we've had. We've had
Right.
stuff coming in from
All over.
All over,
Okay.
yeah.
In which case, we're going to carry on with the standard script, and if you can just give me a nod when you found it and when it's ready, we'll bring it in at the next suitable break in flow. So
Sorry, Chair, can I just ask, when you say third party, is that a third party that's made a relevant rep, or
well, they
just some other sort of associated
no,
person
it's
in the
somebody who's made a rep who sent it in, but they've obviously got it from
ether? Yeah. Okay. No, that's
another party who's made a rep. If that makes sense.
Okay. So let me know when it's ready. In the meantime, if you'd like to make your statement, please.
Thank you for providing us with the opportunity to talk to you today. Laura and I have prepared a statement which I'll read to you. We're local residents and have been asked by other local residents to voice our concerns to the licensing variation made by Southsea Brunch Club and share the experiences that we as local residents have had since SBK has been in operation with regards to public nuisance and crime and disorder. Public nuisance and noise, particularly distressing, is the screaming and shouting in the early hours of the morning by groups of people. This has significantly increased since SBK has been in operation. Residents report having children woken up, having to move bedrooms, use earplugs, and no longer being able to have windows open at night. Loud music is also disturbing into the early hours, made worse when the SBK front and side doors are open. Some residents have reported noise disturbances to the local authority. There is an increase in the number of taxis and cars pulling up in the road at all hours, creating further noise and disruption. Public nuisance litter. Since SBK has been operating, there has been an increase in cigarette butts, disposable vapes, broken glass, beer cans, condoms, sanitary items and chewing gum on the streets of Elm Grove and St Peter's Grove. Staff have left bins overflowing with debris in the street. Crime and disorder. There have been a number of incidents of people urinating in driveways, in the street and even against someone's house. I have witnessed a female customer of SBK removing a tampon and leaving it in the street before returning to SBK. And I would make the point that I have seen them leave SBK and return to SBK. They were an SBK customer. People have vomited on the pavement outside SBK. Residents have seen drug taking occurring in St Peter's Grove and drug dealing at the back of the co-op on Elm Grove. Residents have seen people having sex near the rear of the funeral parlour on Elm Grove opposite SBK. Residents have found people sitting on cars, and there has been recent vandalism to vehicles in the form of broken wing mirrors, including my own son's wing mirror 2 days ago, and scratch paintwork. Some incidents have been reported to the police. Residents have had glass bottles thrown into their gardens, and even people entering gardens and breaking plants and vomiting. The pavement outside SBK is very narrow. The crowds of people congregating outside the building leads people to have to walk into the road to get past them. Where local residents have confronted antisocial behaviour, there have been threats of violence and abusive behaviour towards them. I myself was verbally abused and intimidated on Saturday the 7th of October by a group of men when I asked one of them to not urinate in a driveway in St Peter's Grove. Local residents have witnessed fighting between SBK customers in the street. We're aware of how incidents can escalate, such as the serious incident of a serious assault against a resident that took place recently outside Monty's Bar in Castle Road. As a result, local residents are frightened to confront drunk and aggressive people about their antisocial behaviour. Our conclusions. It is our collective view that there is a causal link between the SBK operation and the recent upsurge in antisocial behaviour and criminal activity in our neighbourhood. Furthermore, these issues are existing issues within the current SBK restaurant licence. We all fear that these proposed variations to the SBK licence would exacerbate an already intolerable situation, and the licensing variation that has been proposed by SBK does not allay these fears. It is deficient regarding how SBK will promote the licensing objectives with respect to crime and disorder and public nuisance, such as the issues that I've just mentioned. Our objections and concerns are so severe that most residents' quality of life has been negatively affected, and some residents can tolerate it no longer and are even considering moving from their homes. The Licensing Act 2003 gives local people a bigger voice in licensing decisions, and helps local authorities create safer and more civilised evening and nighttime economies. In light of the fact that licensing law will always be part of a holistic approach to the management of the evening and nighttime economy, and will focus on the impact on local residents and on public nuisance caused by specific premises, we look to you to refuse this variation to the SBK licence. Thank you.
Members, I've got that video if you want to see it.
Yes, if we could, thanks. We will come to questions, don't worry, and the other statements, but let's have this video first. Before we continue, I'd just like to ask the residents, would you rather that members and other parties are able to question you individually, or would you like to both make your statements and then take questions collectively?
I haven't consulted, but my view on this is that our points are probably going to be quite different. And my feeling is it might be, if there are questions regarding this, then it might be useful to hear them now.
Okay, we will take them separately then.
Is that okay with you?
Okay. Members, do you have any questions regarding the first statement from the residents?
Do you want me to ask the resident something?
If you have questions to ask, please do.
Yes.
Relating to the statement that was just given.
Okay, not the first one.
Okay. And no, I don't have any questions either. Do the applicants have any questions for the residents?
I don't, but I guess I should stress that doesn't mean I agree with what was said, but he's put his points clearly. I have no questions. Thank you.
Anything from licensing? Okay, and then we'll move on to the second statement, please.
Thank you. Before I start, just a little background to that last video clip you heard. It was recorded by my sister-in-law in her bedroom. It's only the audio that is of any importance. She lives in St Ursula Grove. St Ursula Grove is opposite number 18 St Peter's. So you go 9 houses up St Peter's. She lives in number 10 St Ursula Grove, so she's 5 houses along. So that hopefully gives you some idea of the distance away. And as I say, there is this email which Mr Walsgrove has seen, and I take his point. He's raised the point about the timing. CEST shows on all of the emails that we've received from the DPS. It stands for Central European Summertime and is 1 hour ahead of our time. He raises the point that that wouldn't be on there, but as I say, it's on all of the emails that we've received from Sam, the outgoing DPS. That's all I wanted to say about that bit. I'd like to, this is really probably a point for Mr Atchell. There's a document here which is Portsmouth City Council Statement of Licensing Policy, which no doubt he's familiar with. And para 3.1 of it says, Section 5 of the 2003 Act requires a licensing authority to prepare and publish a statement of its licensing policy every 5 years. Such a policy must be published before the authority carries out any function in respect of individual applications and notices made under the terms of the Act. Para 3.4, a little bit further down, says this policy will commence on 12th July 2017 and remain in force for 5 years, which means it expired on 12th July 2022. He might like to check whether a new policy has been consulted on and adopted.
I might actually invite Mr. Stone to answer that, or well, whoever knows the answer.
Well, it's a rolling process of review, and as I understand it, the policy is going to be returning for consideration, but the extant version remains in force for the time being.
I understand what you're saying, but it's not actually what it says. It will remain in force for 5 years. It doesn't say it will remain in force for 5 years and carry on until the new one's
Well,
out.
that may or may not be the case, but my advice to the subcommittee is that it's to apply the current existing policy, certainly for the purposes of today's hearing. I'm not entirely sure where this line of questioning is actually going.
I'm
What point-
only raising it as a point of issue to you, for you to check. I don't wish to lay any great weight on it. Another thing is the current premises licence is a transfer of a licence granted on 29th September 2005. That licence, which is reference LAPREM/6097, was originally granted to a Mrs. Somporn Main trading as Bangkok Spies. So that's the original licence that has been transferred on and on and on. It is showing on the licensing portal as expired, and you may care to check whether that it's still valid or whether a new application is required.
Can I answer that? Just to tidy it up.
Yes, of course.
So the licence is valid. The one that's in the pack is the valid licence. On Portsmouth register, where old licences are transferred, they may then say expired if that's expired, as in the licence held by the previous person. It doesn't mean the licence is expired. It just means
I
that
don't
one
have a problem with
held
it.
by
It's
that.
just housekeeping. Right, on page 31 of the document pack, it's to do with the CCTV, I believe. Yeah. The applicant seeks to remove condition 2 of Annex 2 on page 31 and replace it with alternative wording. The effects of allowing this would be far-ranging. The existing condition requires the CCTV to be fully operational whilst the venue is open to the public. That is to say, the venue cannot open without fully operational CCTV. The applicant wants to replace this with a recording CCTV system will be installed and fully operational at all times. All equipment subject to breakdown, in which case the venue shouldn't operate until it's been returned to service. The committee can't rely on the applicant's statement. The existing statement is absolutely clear, and I see no good reason why the change should be allowed. The applicant seeks to remove the requirement that the recording equipment should be stored and operated in a secure environment with limited access to avoid damage, theft, unauthorised viewing, and maintain the integrity of the system. Obviously, CCTV images are fairly sensitive under the Data Protection Act. It also says a record should be kept of any access made to information held on the system. These are all requirements of the Data Protection Act, and there's no good reason to remove them. The applicant seeks to remove requirements for staff training. Again, that's a requirement of the Data Protection Act. He seeks to remove the requirement for a simple operator's manual to be available and for the regular change and replacement of tapes if used. Again, no case has been made for removal of the condition. Section 2312 on page 20 of the Council Statement of Licensing Policy in relation to conditions requiring the use of CCTV includes: the licensing authority would wish to ensure that the precise location of cameras are identified on plans to ensure that certain areas are properly covered and to avoid any uncertainty or dispute as to the terms of any condition imposed. The plan that's attached to the application does not include the location of any cameras. Mr. Stone doesn't appear to have picked up this discrepancy in his report. To operate a CCTV system, it requires registration of the premises with the Information Commissioner's Office. I've searched the register and there is no such registration for these premises shown. It's also a legal requirement that people are informed that they may be recorded by clearly visible and readable signs. No such signs are visible either inside or outside the premises. This indicates a disregard by the applicant of his responsibilities. Regarding the reduction in the number of restaurant covers, as I've already said, the replacement wording is for 70 seats. Well, 70, as I've said, 70 seats could be 70 chairs stacked in a corner. They don't have to be places where people can sit and eat. The applicant seeks to remove condition 1 in Annex 3, which is on the top of page 32 of the document pack, limiting the number of people in the bar area to 25. Mr. Stone has acknowledged that the applicant in its own Instagram posts published a photo showing the condition had been breached. Mr. Stone wrote, "I have seen the social media post which shows more than 25 people at the bar, and the DPS and owner have been advised through their solicitor to comply with the existing premises licence conditions." This isn't a newly issued licence, it's been around for a long time. Yet there is no mention of this discrepancy in Mr. Stone's report. Removal of the limit of 25 people in the bar area would effectively change the premises from being a restaurant into being a bar. Anyone could go in there, go up to the bar and buy a drink. They wouldn't have to have a meal. The same applies to removal of the condition that removal of the condition that alcohol be supplied only to persons taking table meals there and for consumption by such a person as an ancillary to his meal. The applicant wishes to change this to read simply, substantial meals shall be available until at least 90 minutes before the premises close. The effect would be to change what is now a restaurant and which the applicant's solicitor has agreed is a restaurant, to change it into a bar where anyone could go in and have a drink. And for those reasons, I feel that the application should be refused. Thank you for your time.
Thank you very much indeed. Members, do you have any questions relating to... No, thank you very much. Does the applicant have any questions relating to that statement?
Likewise, sir, no questions, but obviously that doesn't signify any agreement to what's been said.
Thank you. Anything from licensing?
No, nothing. Thank you.
Okay, thank you very much indeed. So, before we move on to the summations, I am just going to give everybody one last opportunity for if there's anything else that you wish to say, to have taken into consideration before we move to the summations. Has everyone had the opportunity to say what they want, ask what they want, find out what they want of anybody present? I do have one very quick question for the applicants. Obviously, we've heard quite a few concerns and a few ideas on what sort of things the residents might want to hear. Not saying that we're going to make a determination one way or the other until we've done our deliberations, but would you be open to, for example, having the opening hours on the licence match the existing opening hours rather than theoretical? Would you be open to changing the word seats to the word covers? Would you be open to having no new customers entering the premises after a certain point in the evening to try and prevent it becoming like a late night drinking establishment and focusing more on the restaurant side? What sort of degree of flexibility do you have on those sorts of areas?
I think you've already been advised in terms of the hours. I mean, you can't, that's not a consideration to reduce the hours on the premises licence, not part of the application. If you choose to use the word covers instead of seats, there's no objection to that. I mean, it's operating as a restaurant. We all know, obviously the residents don't, what a seat means. It means you're sat down at a table. And obviously we've told you the primary purpose of this place is to provide meals and for people to eat there. Again, whatever words you choose. As far as the last entry time is concerned, we don't consider that is something which is actually necessary. It's not a case of the issues that have been raised are as a result of people coming, you know, in the very last knockings of when the premises are open and causing an issue. They're objecting to the premises sort of generally, that the clientele that are there are causing an issue. So I don't think that that's necessary, and it's not something we would suggest you consider when looking at the merits of what we've actually applied for, which is to approve a plan, obviously tweaks to the CCTV condition, etc., etc. And then it's just this: is the dynamic of the premises going to change at all by having the substantial food condition and the reduction of the number of seats? So again, I'm not sure a last entry time does anything towards that. So.
Okay, thank you. And one other question. Does the venue currently have a noise level monitoring system in place for recorded and live music?
We've got a system that has been set with EHO and has been tweaked with EHO that it can't go above that system. That has come from recording levels that were taken from a complainant's bedroom, so that they've then said, right, can you reduce, and I don't know the terminology because it's been done by experts, and we've reduced the levels to a level that they're happy with, and we've had no issues on that sort.
Okay, thank you. Any further questions before we move on to the summations?
Sorry, just one last thing. So if there's no fundamental change to the use, why are you removing the phrase ancillary to a meal then? Why don't you keep that? What's the problem with that phrase about drink being ancillary to a meal? I don't really understand why you'd want to
I've already
remove that.
explained that is who defines what ancillary is. Does that mean a limit on the number of drinks you can have after you've finished your eating, the limit on the amount of time you can spend in the premises after you've eaten?
So it doesn't matter if it stays then, that phrase then?
It doesn't to us, but we think it's better and clearer to have an enforceable condition. Having it as ancillary, everybody's going to be saying, oh, well, they've been in there just having a drink. And then you get into the issues of, well, when did they eat their meal? How long have they been here? Etc.
Yeah, but if it's fundamentally a restaurant, it doesn't matter then, does it really?
Well, it does for the reasons I've explained. I can't answer it any more clearly than I have, I think.
We're going to move now on to the summations, so I would like to invite the residents to briefly summate their case if they wish.
Sorry, I don't quite understand what that means.
So based on everything that's been said, heard all the questions, do you have any closing statements?
The closing statement that I would like to make is that we are a group of residents who are not familiar with coming together and making complaints. We've lived in harmony with our business neighbours for 20, 30, 50 years. It's a settled, long-term neighbourhood. So this is unfamiliar to us, and is not an easy process to get into conflict. And this is our lived experience. So I'd ask you to take into account how seriously we take this, to come to you today, how uncomfortable it is and intolerable it is at times. I was mocked for walking through someone's urine the other day by a group. I was threatened by a lad who I challenged. And they were potential customers. They were trying to get into SBK. Steve, to his credit, and his team dealt with that well, and reduced the sense of victim status that I felt. But that is the experience that our residents have. One couple couldn't gain access to their home because two lads were busy urinating up against the side of their door. And when they said that this is disgraceful and that you need to get out of our way, they were threatened, and they were told, what do you expect, living so close to a club? So whatever you're hearing, in my view, whatever you're hearing that is suggesting that this is not a problem that arises from SBK, my and our lived experience is that it is. And I'd like you to take that into account, please.
Thank you very much. Anybody else from the residents like to make any closing statements? I'd like to invite the applicants to briefly submit their case, please.
Thank you, councillors. Very briefly, just like to remind you that the Environmental Health and Police did not make a representation against the application, and according to the guidance issued under the Act under Section 182, you are to look to the police, particularly as the experts on the issue of the crime and disorder licensing objective, and to environmental health in relation to public nuisance, and attach weight to what they say, what their opinion is, unless there is credible evidence to suggest that their opinion is incorrect. And we say that it's not, that you should attach weight to it. If there were the levels of antisocial behaviour and public nuisance that the residents have asserted, then they would surely have made an objection to this application, and they have not. It is a difficult decision for you because obviously there are two completely conflicting accounts of what is going on in the locality from us and from the residents. I just ask you to strike a balance between the needs of a business and its continued economic success and the needs of the residents. You've heard that Steve is going to play a much more proactive, hands-on role with a new management team at the premises, and has set out very clearly his intention to try and work with the residents to address some of their concerns, certainly in relation to any, what we would say, are more exceptional incidents of SBK customers causing any issues, and more broadly any wider antisocial behaviour issues that there may be. And I'm noting in particular here the issues of drugs, which is not an issue with SBK, but from my experience of other licensed premises, that is something which is happening in that area, not associated with licensed premises. It's a general problem that, unfortunately, that local community are having to deal with at the moment. And SBK are happy to work with the police and residents on whatever measures need to be taken to try and address that, because nobody wants to see that. It's not going to benefit my client's business having the reputation that nearby people are taking drugs. So I would hope, after having heard all you have, that you would be able to grant the application as we have applied for. But if you do have concerns, then obviously you need to just break down all the different elements of what we have applied for. So I did that for you at the outset in terms of the plan and then the separate number of conditions. My final point is just in relation to the CCTV. The CCTV condition that you're being asked to put on the licence, which is the revised one agreed with the police, that's the CCTV condition that's now going on every licensed premises in Portsmouth. It would be odd for you not to put that licence on. And if, to be honest, I can't off the top of my head recollect whether it mentions the things that the interested party mentioned, but he said all of the requirements that he said were missing are under the Data Protection Act, which I know to be true. You should know that under the guidance, you're not supposed to add conditions to a premises licence where there's an obligation required of the licensee under another statute. So all the thing that the Data Protection Act requires us to do in relation to CCTV, we are doing, and all of those obligations fall under the Data Protection Act. So if there is any element which is missing, it doesn't matter. You don't need to revise the condition because we're obliged to do it anyway. So I'll leave my submissions there, and thank you for taking the time. I know it's a difficult decision for you. Just want to emphasise Mr Hudson's willingness to work with the residents, and during the break he will provide the relevant contact details for himself and the manager.
Thank you very much. And I'm just going to double check with Ben. My understanding is correct that regardless of what is or isn't in a licence, anything which is part of a national law still applies. And also, national laws override contract law. So anything which is, if you have a clause in a contract or a licence that goes against the national law,
condition wouldn't
the national law overrides it.
Yeah, the condition wouldn't amount to a contract in any event. But it's quite right what you've heard. The guidance does indeed say that conditions ought not to duplicate other regulatory regimes where there is legislation that provides for their enforcement.
Thank you. Does that allay your concerns around the CCTV specifically? It's all covered under Data Protection Act. Is there no current signage at the venue?
So the signage, I think when the refurbishment work was done to the lobby, the sign was taken off, which it shouldn't have been, to be perfectly honest. It should be there all the time, but there is signage there.
It's now been put back up?
Yeah.
Okay, thank you. Before we go into adjournment for deliberation and some lunch, would anybody present in the room, either from licensing, the applicant, or from interested parties, or from members, like to make any more statements, any more questions? Is everyone satisfied they have had their opportunity to make their case?
Can I just ask a question? I know that there was something about the address of the police. Am I right in understanding that the main central station is reopening soon? Winston Churchill Avenue. Did I see that in the news?
I'm unaware of that. The address that was in the conditions on the licence was for Kingston Crescent Police Station.
Oh, was it? Right, okay.
Which is definitely closed. And I think, to be fair, it's, for a licence to specify which police station they should report issues to is probably not appropriate. The fact that they need to report it to the police at all is sufficient.
Yeah, okay. I just thought it might be quite handy if it's opening to have a quick response time. Okay, thanks.
No problem, thank you. Okay, if everybody is satisfied they've had their say, we're going to adjourn now. We are going to be deliberating for quite a while. I'm going to say don't expect us to come back until 2 o'clock in the afternoon at the earliest. That will also allow Ben and myself and the members to nip to Sainsbury's and grab a quick sandwich while we're deliberating. So at the earliest 2 o'clock, it might even be after that. Thank you.
And just to reiterate again, I know I probably don't need to, but just to say, if you do happen to bump into any of the members between now and them reading out the decision, they won't engage in any conversation. They will ignore you strictly on my instructions, because any any kind of contact with them between now and the decision being announced causes all kinds of problems. So just to explain. Thank you.